So I'm Lance Liebman. I teach at Columbia University in New York, and I opened this thing and said everything I had to say early this morning, and it's been a very good meeting since. And this is the final session, and the subject is called policy issues. We've been talking about these policy issues all day, but I'm sure there's always more to learn and to hear. So three of my colleagues are here. Professor Estreicher stepped outside. He'll be back in a minute, but we're not going to wait. So Catherine, would you just start with the introduction and just say who you are, and then Emily and Kelly will, and then we'll get going.
Great. Hi, I'm Catherine Edwards. I'm a researcher at the Economic Policy Institute.
Emily Spieler, I'm the Dean of the Law School at Northeastern University.
Kelly Ross, I'm the Deputy Policy Director for the AFL-CIO.
And I'm now acting for him. I'm Sam Estreicher down at that end, and I'm a law professor at NYU. So, Catherine, why don't you just start, okay?
Yeah, sure. Well, first, thank you for having me here today. I should first say openly that I am a former unpaid intern, and every benefit that you can speak to when it comes to unpaid internships, I mean, I can speak to them. The experience, the opportunity, the connections, the exposure to a field, and realizing it was what you wanted to do. But I would still, stand, or rather sit before you today to say that I think the system demands to be changed. And I come from this on both sides, both the worker side and the employer side. If you put a price tag on anything, it's going to put people from a lower income at a natural disadvantage. Although unfortunately the data concerning interns is not as reliable or as prevalent as we would like, intuitively this is easy to understand. If you put a price tag on something, poor people are going to have a harder time affording it. And essentially what we're talking about now is a price tag for job opportunities. Now, think about it this way. If an unpaid internship in DC conservatively costs $4,000, and for a family of four living at the poverty line, that's about a fifth of their income, if not a little bit more. Now, a family, a median income family, so if you take every family in America and you have the rich on one end and the poor on the other, and you grab the family in the middle, that's still about a 10th to a 12th of their family's income. But if you start heading towards the richer end, the top 10%, it's a 50th. Top 1%, it's closer to, a 75th, a 100th. I mean, it's getting smaller as you go up. And it's very easy to see why people at the bottom are not going to be able to afford it, considering what it represents for their family's income. But even on, the employer side, think about it this way. If all unpaid interns instead made $1, and they made $1 an hour, or even $1 for the summer, if they made even some, small pittance of a wage, we would not be having this conversation. Because if there were 1 million kids who were working in professional settings making $1 an hour, it would be very clear to everyone that this is a violation of the law and that they should be paid the minimum wage. But the fact that they're not paid at all is what raises the question, should they be paid at all? If there was a smaller wage paid to them, it would be very clear to us that people should not be working for below a minimum wage, just because they happen to be college students or just because they happen to be willing to. I mean, it's a bad economy. The unemployment rate for college graduates over this past year has averaged above 9%. 9%. That's almost 1 in 10 college graduates under 25. So that if you take everyone who's graduated from college in America and everyone who's older, don't look at them. We're just looking at people who are under 25. So you're looking at essentially 21 to 24-year-olds. Their unemployment rate for the past year has been over 9%. That's getting on the national unemployment rate, which is 9.6% right now. Now, in a period of economic expansion, we would expect this to be closer to 5%. And may I bring this up to put unpaid internships in context of what economy we're dealing with. I mean, economy-wide right now, we are looking at a gaping hole in our labor market of around 11 million jobs. Now, this is not just the jobs that we lost, right? This isn't just we had an economy growing and we lost jobs. The economy, job growth is a moving target because you have to make jobs for the growth, to keep up with the growth in population. And when you add that together, not only the jobs we lost, but the jobs we didn't make since the start of the recession, we're roughly 11 million jobs short. All of this is the context in which unpaid internships currently exist. Income inequality, unequal access to these, which are essentially become job opportunities in the context of a very difficult labor market, especially for young people, but indicative of the economy overall. So for us, when it comes to unpaid internships, for me, it's very clear that these should be jobs in our economy and not resume builders for students who can afford it. Now, that sounds harsh, that sounds caustic, to write off an experience that someone, even as myself, benefited from, but it's honestly what we would believe, that these should be jobs in our economy. If someone is getting paid, or if someone is doing work, they deserve to get paid. And in that sense, I think I'm trying to shift the conversation from unpaid internships to unpaid work. In that regard, the Economic Policy Institute has proposed a two-part test, which is frankly is if your per hour cost to the employer are greater than your per hour benefits, or other way around, other way around, you should be paid. Essentially, if your employer is benefiting from you more than you're benefiting from them, they have to pay you. Essentially, if you're doing work, you have to be paid. So when we talk about policy reform, essentially, and I was saying this to a few people at lunch, you design for the worst case scenario when it comes to worker protection. In an ideal world, there's a student, she's a freshman, she's got an internship, she has a stipend from a scholarship, she's constantly in touch with her career advisor, and she writes essays about what the internship meant to her, and it all went well. But we don't design policy for her, because she's okay. We're gonna design policy for people who, the worker who starts work and she's sexually harassed and suddenly the Civil Rights Act doesn't apply to her. We're gonna apply policy or design policy for people who are told that they don't get to have an internship because they're too old, and it doesn't really fit with they don't fit with the vibe of the rest of the interns because they're a returning student and they're like 35. We don't design policy. We have to design policy for them, or you know what, our interns have to do a lot of errands, so you're in a wheelchair and I don't think it would work out. That is who we design policy for. And in the same sense, if it applies for their workplace protection of the Civil Rights Act, the Americans with Disabilities Act, and the Age, Employment, and Discrimination Act, it has to apply for them in terms of as they are as workers. So we're not just talking about freshmen who are getting a 6-week stint as an internship. We're talking about college graduates who are told they have to work unpaid for 6 months before they can get hired at their office. We're talking about people who are laid off at companies and told that they can come back as interns and eventually they'll be paid when the economy recovers. That's who we design policy for, and that's when we say this is about unpaid work. They deserve to be paid. If you do anything for an employer, you deserve to be paid. And I just want to say that, in short, we want to design a system that protects workers, because that's what they are. If you do a job, you're a worker. No matter what experience you derive from it, you're a worker. And Mr. Kudkowitz, who I believe was on the last panel, he said something that really struck me. He said that in his opening remarks, he said, in a period of economic downturn, employers are looking for alternative ways of dealing with their labor needs. Alternative ways of dealing with their labor needs. Well, it doesn't really matter to me if you're a college student. It doesn't really matter to me if you have a disability. It doesn't really matter to me if you have 2 college degrees and you got laid off and you want to try out a new field. There is only one way to meet labor need as an employer, and that is with a paycheck.
Thank you very much. Kelly, would you go next?
Thank you. From the perspective of the AFL-CIO, which is for everyone, I hope you know, that America's labor movement, we have three main concerns. One is the degradation of labor standards. 2 is the role this has in exacerbating inequality, and the third concern is about workplace protections. On the first issue of the degradation of labor standards, it's natural in this kind of economy, as I think Catherine just described. You have more and more employers who prefer not to pay wages for the work that's done for them. You have more and more people who are willing to work with little or no pay because they need that position to advance their careers. So this is a growing problem in this kind of economic condition. And as this becomes more and more prevalent, more and more employers are going to say, why should I be paying for work? Why don't I just get unpaid internships to do more of the work that needs to be done? And you have a gradual race to the bottom. That's why we have minimum standards. That's why we have the FLSA. That's why it was passed in 1938. Because if you don't have minimum standards, employers will always want to get work for free, and there will always be people who want to do work for free. And that's not a tolerable situation. A lot of this debate that we've been hearing today, and thank you for having this event. The debate we had on the previous panels was very instructive. The arguments that we heard are arguments that we regularly hear. Those of us who work on the minimum wage and overtime issues, you hear year after year. They're very familiar arguments. For example, a couple of years ago, the Bush Labor Department pushed through some revisions to the rules for who is eligible for overtime pay. And the argument that they and people have been making for years up to that point was that the current rules are outdated. The FLSA was passed in 1938. The economy has changed. We need more flexibility. We need bright line rules so employers know what the law is, and we said those arguments are all wrong. And if what you really want is bright line rules that are easy to understand, how about a bright line rule that actually protects more workers? And they said, oh, wait a second, no, we don't want that. There's no, you can't have a one-size-fits-all solution. Well, which one is it? And this is a good example, because if you look at what the Wage and Hour Administrator said in the New York Times article in April, and if you look at this fact sheet number 71, which you have in your packets, it's pretty clear. Internships in the for-profit private sector will most often be viewed as employment. And I'm totally in agreement with Michael Oswald from the previous panel from the SEIU. It's a pretty clear test. The problem is that employers don't like that test, and they want to change it. It's not that it's hard to apply. So I would argue for doing exactly what the Wage and Hour Division is doing, which is getting the word out there about what the law is. I think a lot of the problems we're seeing is that people just don't know. There has not been sufficient work in the past on letting employers know what the law is. This fact sheet number 71 also says that they are giving consideration to addressing internships in public sector and nonprofits, and I would encourage them to do that as well, so that everyone is aware of what the problem is. The second main concern we have is inequality, and other people have touched on this, but the bigger picture here is that one of the biggest reasons we are in the economic mess that we're in right now is because we had growing economic inequality. This was the first economic recovery since World War II where family income actually went down during the recovery. Economic inequality was at its highest level since 1928, and that was a contributing factor to this crisis for reasons I don't have time to go into now. But the upshot is that we think that combating inequality is something that we should be focusing on in a wide range of issues across the board, wherever we can, however we can. And if you look at this problem of unpaid internships in the context of growing economic inequality, it's clear that there's two sets of problems. One is employers who are just violating the current law or the current six-part test, and the other problem is that even if all employers followed that test, and especially in public sector and nonprofits, you would still have some unpaid internships that would still be contributing to this problem of growing economic inequality. So the solution is, one, better enforcement of the current law, and two, finding ways of making it possible for more students and individuals to be able to participate in these unpaid internship programs through things like the EPI's proposal for grants and subsidies for student interns. And then lastly, the workplace protection issues that Catherine mentioned, the fact that interns are generally considered not to be protected by civil rights statutes, age discrimination, ADA. I think that would require some kind of legislative action, which probably does not look very likely in the current context, but it's something that we would support. And lastly, I just say that this is not just an issue of inequality in terms of minorities. I think this is a class issue. This is which is related, but it's not quite the same thing. This is about people from all kinds of economic backgrounds being able to get the kinds of positions that will advance their careers, and not having these kinds of positions reserved for people from higher economic income backgrounds.
So just for clarification, are you saying, Kelly, that you'd be in favor of a rule, no unpaid interns in for-profit employers?
I didn't say that. I said
well, that's what I'm asking.
I said the current rule is pretty clear that it's unlikely. If you can structure a program
that
where
meets the six-part test,
it's really a training program for the benefit of the student, then I see no problem with that being considered.
Okay, and so the same six-part test, you'd say, fits both the profit sector and the nonprofit sector?
I think it doesn't currently. The question is whether you should apply that test to the nonprofit sector. I'd be open to some modifications there. I think there is an issue of displacement of workers, even in the nonprofit and public sectors. So but whether you need the exact same test, I'm agnostic.
Okay,
at this point.
Interesting. Emily.
I'm not sure I'm going to be as bright-lined as the prior two speakers, although I have to say I shared your concern when I heard Mr. Kutkowitz say what he did, since it clearly was an indicator that the economy is driving the desire of for-profit employers to expand their unpaid workforce. A couple of sort of things by way of introduction. For those of you who aren't familiar with the program at Northeastern, and now I'm talking about the university, not necessarily the law school, although we can talk about that as well. In 2009-2010, Northeastern placed around 7,000 students into positions, co-op positions out in the community. Of those, about 750 were from the law school, and the rest, almost all the rest, were undergraduate placements. The vast majority, well, let me say, the number of unpaid private sector placements among these was very small. Although in the law school, the nonprofit and public sector positions often do not pay, and we provide, to the extent that we're able, stipends for those students. The expectation for co-op programs historically has been that students would be paid, and now in the university about 10% of the placements are unpaid, but almost all of those are in the nonprofit and public sector. Now, I would say there was more than a bit of consternation in the senior leadership at Northeastern University when Fact Sheet 71 appeared on the heels of the Greenhouse article in the New York Times. And there's been an outpouring from the Northeastern leadership on the issue, taking a quite public stance and leading, with the president of the university leading others to join him in asking that DOL not intrude into university-supervised programs, and I'll come back to this in a minute. The core conundrum, I think, for a university like Northeastern is we want our students actually to do something useful for the employers they work for. We don't want them to stuff envelopes. We don't want them to load trucks. But we do want them to feel that they're part of a workplace and doing something useful in that workplace. So it's a core conundrum, particularly for me, because my history is of representing workers, and I practiced law for many, many years. And I headed the Civil Rights Division in the Attorney General's office in West Virginia for a few years, and we used to take summer law clerks. Now, my experience with summer law clerks was that they were more trouble than they were worth, and it would never have brought them on if I had to pay them. They took a lot of my time, and I wasn't sure what they gave me I could use. So I was happy to bring them along to depositions and trials, but when they wrote memoranda or briefs for me, they often required a significant amount of work. The other thing you should know about me is that I started my legal career a very long time ago representing the Cambridge Hospital House Staff Union in Massachusetts when the issue was, are they employees under the National Labor Relations Act, under the Massachusetts Labor Relations Act, at a time when the National Labor Relations Board had decided that interns and residents were students and not employees and therefore not allowed to organize. Now, I say all that because it provides some background for what I'm about to say. So first of all, what's changed in the last few years? Why are we all here? Not the wage and hour view, not the Department of Labor view. They actually haven't changed their view at all. What's changed is the explosion of unpaid internships, and I think that should give us some pause, particularly the eagerness that was recently expressed about expanding that. And the other thing that I think is also, that's important to remember is that the issue is much broader than whether students are going to get, or interns are going to get, minimum wage. For one of our law school co-op students, minimum wage would essentially give them $3,000 for a quarter's worth of work. But it doesn't, and you know, that's not nothing, but it's not a whole lot of money when you compare it to what tuition is at a private law school. There is, however, as David Yamada pointed out in his article, a real legal void, and we keep coming back to that in the various conversations we've had today about what interns are not covered by, whether it's the anti-discrimination laws or the workers' compensation laws or other things like that. Clearly a problem. So what's troubling right now to me is two things, and they both have to do with what I call creep. One is the expansion of unpaid internships in the private sector, and the second is the expansion of unpaid internships in the postgraduate world. And in thinking about that, my solution is a little bit, it's not like yours, I kind of like yours actually, but I would say that that I think in terms of presumptions, because when I used to be a real lawyer, presumptions often had a real tipping effect because it had to do with who was going to actually put on evidence and win the case. So I would have a presumption against employee status if the internship is part of a degree-based program, understood to be not for pay, under the direction of an educational institution. You'll note I'm staying away from the for-credit issue because I don't think it's the right test. I would say if people are doing menial work, then the presumption fails. The work must, at a minimum, be as useful to the intern as it is to the employer, or perhaps the test of more useful to the intern than it is to the employer. I understand this doesn't solve the socioeconomic problem, and I'm personally tilted against unpaid internships in the private sector, but our school and many schools, I think, are trying to address the socioeconomic problem through other avenues, and that's an important thing for us to do. But I would have a presumption always in favor of employee status when it's not part of a degree program, when it's doing work that even arguably displaces employees or the hiring of employees, when it's not part of a place where volunteerism is appropriate, and especially, and this was actually the tipping point in my litigation in the 70s of the Cambridge Hospital case, when an employer bills out for the time. So, you know, if a private law firm is taking a law clerk and then billing out for time and not paying that law clerk, that's really a problem. If hospitals are putting in the time of people who are working in the hospital as trainees in order to justify billing rates, that's really a problem. I would say that when there's a lack of educational value during the internship as opposed to advancing the career of the individual, in all of those situations, the presumption has to be in favor of paying the employee for the work that they do. I'm very disturbed personally by the growth of postgraduate unpaid internships in order to get a foot in the door. And I agree with the young man who spoke at the end of the last panel from the floor. a distinction really needs to be made in that arena, and I think it hasn't been discussed enough today in the course of this program.
Thank you very much. Sam, I already introduced you, so you're on.
I want to thank Alan for putting together this great program. I don't have strong views on the subject, but I want to raise a couple of cautionary notes and then maybe suggest a procedural route for moving ahead on the issue. The first cautionary note is what I call the nirvana illusion. We very often think that by regulating something, we're thinking about the evil we're trying to eliminate, but we never think about the effects it has. And you've got to think about both of them. So, I mean, for example, there's a ton of litigation now on whether or not employees should be classified as overtime exempt. And that produces some money for the plaintiff lawyer and the members of the class, perhaps. But at the end of the day, they become hourly employees. And it's not clear that the overall benefit going long-term is something that you would have desired. I'm not saying you shouldn't have these laws, but there's a tendency we have to sort of like hit the mole, and then the mole shows up at another spot in a different way. So I just want us to keep that in mind. Secondly, I want us to keep in mind a distinction between the exploitation perspective and the human capital perspective. They're both legitimate, but we don't want to lose sight of the latter. In Europe, as I understand, continental Europe, there's a pretty well-established apprenticeship program. The intuition is that not all valuable work in a society is produced by people coming out of the universities, but there's actually work that's valuable to the society, and people can learn skills on the job. We don't have such a program now, but we should be thinking about something like that. The high schools are not well serving half of their population. I think I would suggest that the colleges are not serving half of their population. I'm even going a further limb. The law schools are not serving half of their population. So, you know, work-based learning would be a good thing, and we should be thinking more about it. I have a master's from Cornell ILR, which is the labor relations school. I'm also very active with the hotel school. Those two schools have terrific internship programs in the for-profit sector, and it's a feature of the two schools. It makes for a terrific educational experience for the students.
Sam,
Now,
are those unpaid internships?
I think they are, but I'm not sure. What the key point is that they're under a kind of educational, imprimatur educational oversight, which I would require. I suspect they are unpaid, but I think I think they are. So I mean, it just suggests that if it's done right, there's a lot of value for the student in building up the human capital. Which brings me to a third point. I don't know how the AFL-CIO or any other organization can say that this contributes to growing inequality. I mean, it's a very complicated econometric exercise I'm going to have to engage in. It may be that if you don't get paid for the first 3 months, you know, you're at loss for those 3 months, but you're not necessarily better off in a minimum wage job. It depends on what happens to you over the course of your career, what happens to you over the course of the next 2 years. I just don't know how we can say, you know, ex ante at the outset that this is going to contribute to growing inequality. The sexual harassment thing, I mean, first of all, if you're working for an employer, you don't have to be an employee. You still have a claim. It's the tail wagging the dog. There are ways we can provide protection. The university might be on the hook if it's part of a university program. I just wouldn't want that tail to wag the dog. Profit versus nonprofit. This is something Alan Morrison was suggesting. I don't think that's going to work. The labor board back in the old days used to take the view they were not going to exercise jurisdiction over non-for-profit organizations, and they gave way on that because the not-for-profit organizations are enormous employers. If you think about the growing industries in this country, they are nail care and pet care. They're for-profit. Universities and hospitals. Those are the 4 growing industries in this country, and 2 of them are not-for-profit. We're never going to draw the line there. It doesn't make any sense, I would argue. The stipend approach is very interesting. The problem is you give a stipend to the employer is going to have to pay employment taxes. So they're going to want to go back to the university for employment taxes. To solve the problem, the university is going to have to pay the full bill, I think. This brings me to my last point, which is procedural, legal process, whatever you want. The Labor Department actually has very little business in this area. The only business they have is to make sure people are not employees. That's the only business they have. And, by the way, they've only issued 2 opinion letters and a fact sheet, and there's no statutory or regulatory authority cited for their fact sheet. Let's go through their fact sheet for a moment. This may have happened earlier, but it's not a very well-written fact sheet. First of all, number 1, in the internship, even though it includes actual operation of the facilities of the employer, is similar to training which would be given in an educational environment. That's just a very poorly written requirement. It's not going to be similar to an educational environment. It's going to be some actual operation that's trying to make money. And there's no point in having the employer set up a classroom. I don't think that's the key. The key is that there'll be some learning and some feedback on the work experience at the university. So I just think it's miswritten. There should be an educational dimension to the internship. That's not what 1 says. 2, for the benefit of the intern, that's fine. 3, does not displace regular employees. It's okay if you don't take it, that's fine. I have no problem with that. 4, no immediate advantage to the employer. Idiotic. If it's no advantage to the employer, it shouldn't be done. And the employer's not going to do it unless you pay the employer. So there should be an advantage to the employer. Now, it's been suggested we have this per-hour cost versus per-hour benefit. It's so complicated. If I were an employer, I wouldn't do any interns unless you paid me. There can be an advantage to the employer. There should be an advantage to the employer, in my view. The intern is not necessarily entitled to the job at the conclusion of the internship. Idiotic. I don't get it. We want you to work for us for nothing, and we don't want you to have a job at the outside. If we were designing this post-revolution, we're in a revolutionary era now, we want to break down the society, but let's assume we're in the post-revolutionary era. We care about people and care about a society. Aren't we going to want them to work in unpaid internships that lead to a job? That's what I would want. 6, the intern and the employer agree that the employer is not entitled to wages for the time spent in the internship. Well, first of all, these contract requirements don't make a lot of sense, and why should it specify that you're not entitled to wages? Maybe there ought to be wages. It's not a well-written document. It does not have a lot of resonance in the statutory language. It's not grounded in any regulation. It's time to look at it again. This is what I recommend. Here's my procedural recommendation. Alan Morrison put together a group of smart people, able people, knowledgeable people. We go meet with the Labor Department, have some form of negotiated rule that makes sense for the variety of contexts. And I think, by the way, Labor has enough to do. The Labor Department has enough to do without going after university-supervised internship programs. I don't care what that fellow said at DOL. So let's provide some guidance here. Let's do it in a way that makes sense. We don't need to write law review articles about it. Let's get the Solicitor of Labor and these other folks commence a rulemaking and set up university-supervised programs that make sense. And in some settings it should be paid, but I don't know if it should be a legal requirement. In some settings unpaid, and if the universities have money to pay stipends, there ought to be a way to do that. Maybe bring in the state labor departments so they don't get agitated about workers' comp. I think there's a way we can do this that makes sense, and we should try to do it. Now, does that mean we let employers have a free ride? No, because it has to have, for me, an educational payoff, educational oversight. And if it doesn't have that, then it's work. Because we don't have the mechanism in place now for an apprenticeship-type program. I wish we did, because that would be a good thing. I'm going to go back to the proposition that even our law schools, half of those folks are not being well served. What do I mean by that? We teach them legal theory. We teach them content working. They need to hang out a shingle, and they're not being taught to hang out a shingle. Law firms are not going to take them in because they went to whatever reason, they're not going to take them in and train them anymore. So we ought to train them in a way that makes sense, put some durational limit on it, have it under the oversight of the law school. I think it's a good thing. It'd be a good thing for a lot of law schools.
I know there are people on the panel ready to respond to others on the panel. Emily, you want to go first?
No, actually, Sam, I was curious whether you were talking only about people who are internships that are within degree programs or something.
At this point, only that, because postgraduate, I see unless there's a postgraduate, they don't have to be in a degree program, but let's assume that your school offers a postgraduate certificate where they would oversee. There might be a way to do that. But in general, as a rule of thumb, my hackles are raised when it's a postgraduate internship where there's no educational tie.
So I totally agree that this is not at the top of the list for the Wage and Hour Division of the Department of Labor at this point. And so the question, I think, or the suggestion you're posing would give us the opportunity to eliminate some of the uncertainty that is affecting behavior when there isn't actually going to be regulatory action. I'm on board.
Good.
Kelly, comments?
Oh, wow, there's a lot there. I just a couple of things. The professor mentioned his incomprehension that I could say that this contributes to inequality and that the individuals would not be better off in a minimum wage job. I think you're missing the point. The point is not to put people in minimum wage jobs. It's to allow more people to have this experience. And if you have more paid internships, then people with lesser economic means will be able to do them as opposed, I, for example, worked my way through college. I was not able to do unpaid internships because I had to work to pay for my tuition. So if there had been more paid internships, I would have been able to do that. So I think that's missing the point. And then a couple things. You were focusing on the 6 tests and saying that 2 in particular were idiotic because the employer is not going to structure a program to make it seem like an educational experience, and the employer is going to get an advantage. But I think if we're focusing on for-profit employers, you can't assume from the outset that this has to work for for-profit employers. That's not a valid assumption from the outset. It is true that an internship program that gets in the way of the for-profit employer's operations may not be attractive to the for-profit employer, and setting it up as an educational experience may not be attractive to a for-profit employer, but that means the for-profit employer fails the test. It doesn't mean that you need to change the test so that for-profit employers
I'm saying that the educational
meet the
experience
test.
should be supplied by the educational institution. It should not be a requirement of the internship that the employer provide it. The employer is not well situated to provide it.
Well, so the for-profit employer
There's no magic about for-profit and not-for-profit. Do you think it's desirable? You start off first by saying you want to expand the opportunities by providing a stipend. I'm all for that. The university should figure out a
I didn't
way
say stipend. I said
to
or
extend.
making them paid internships.
Well, I don't know if they have. There are lots of ways of in expanding the opportunity. If you want to expand the opportunity, you must think it's a good thing. And if it's a good thing, let's not have arbitrary restrictions, which I think at least 2 of those factors are.
It's a good thing if it's a paid internship, and so let's make more paid internships available to more people.
How can you speak for all people, by the way? I just don't get it. I mean, you're a very able person. I can barely speak for, my kids won't even let me speak for them. And, you know, if there's information, if people know what they're getting into, and there's a durational limit, how can you say it's not good for them?
Well, I'm going to interject here. I don't think that anyone here would ever maintain that there has been a culture of rights awareness developed among students engaging upon internships when they're still in school. I don't think anyone would say, yes, we have educated students of exactly what their rights are and what their rights aren't, what the law says and what the law doesn't. I mean, we've been here for 8 hours and we're still trying to figure out what this says, and apparently students know what they're getting into. I mean, that's a point that needs to be made. And I mean, I'm going to go back to the idea of inequality because I think you made it in passing, but it's really important to understand. And when we say that, you know, internships exist in the context of inequality, we're not saying that internships cause income inequality. We mean that they exist in an unequal world. And when we talk about that unequal world, we're not just talking about their families. We're not just talking about who they get support from. We're talking about the students themselves. And in this respect, I'm talking about students who graduate with debt and students who don't. All right, so if you graduate from debt, which is about half or more of all college students, all right, you're graduating with a significant amount. And the estimates for public school for 2007 to 2008 was that if you graduated with debt, it was with about $19,500. If you went to a private school and you graduated with debt, which was about 65% of all private school graduates, you graduated with about $25,500 in debt. Now that's up from 2001, and in 2001, those were, let's see, $9,000 and $4,000 less. Over 7 years, that's how much debt has skyrocketed in terms of what students graduate with. So when we talk about income inequality, what we literally mean, you know, not just on what happens of where these people come from in terms of their families, we mean what financial footing they're on as a 21-year-old college graduate who says you can have an unpaid internship here and it'll last for 6 months. Good luck with that $20,000 in debt. I don't know how you're going to service it, but that's not our problem. That is income inequality. What you have to, what the cards you play with at the table. And so I think that that's important to understand of why we think unpaid internships, you know, why that matters to come at it with a clear perspective. And EPI's perspective on this is to say, look, if the employer gets more from you than you get from them because you've done something for them, that sounds like a paycheck to me. If you don't do anything for them and you're more of a burden to train, you're more of a burden to supervise, you're more of a burden to bring around, you don't actually do anything, you just kind of sit, shadow, you contribute nothing, they essentially spend all their day telling you what to do, that is an unpaid internship. And I want to be very clear, in the type of reforms that we propose, there are still unpaid internships, it's just unpaid work that we're getting at.
So, I don't think there's, I'm going to venture the guess that there isn't anyone in this room who isn't deeply aware of the level of income inequality and wealth inequality in this country today. And I think the question that's being asked, and to me it's not a simple question or a simple answer, but the question that's being asked is, what's the best way to address that? And I also haven't heard anyone argue in favor of unpaid postgraduate internships. The question, I think, would be, to what extent are some of these internships that people do as part of their undergraduate or law school sort of training periods, educational periods, to what extent do they advantage or disadvantage students, and to what extent do they contribute to inequality? I'm not sure I can answer that question, but I would venture a guess that to the extent that we try to make them available to everyone, that the student coming from the lower income family may ultimately be better off. And therefore, the internship programming, or co-op and externship programming, whatever words you want to use, may in fact contribute to lessening the level of inequality going forward. And so I think that, again, I'd like to sort of have us focus in on the questions upon which we do disagree, rather than arguing about the ones that I don't think we disagree about.
Right, and I think that we're talking about means, right? I mean, the income in picture is a long one. It exists over a person's lifetime, and how that changes based on education is something that many people spend their entire lives looking at. I mean, we're talking about means of a person to do a thing, and if it's unpaid, the means that essentially you are required are very different than if it were paid, right? Because if it were paid, when anyone can do it, I think people are really good at getting paid. But I think that if it comes to being unpaid, your means become a different factor. And in that extent, when unpaid internships, paid internships, we all agree that internships are a good thing because of the school to work transition, because they're the training aspect that's often missing in the classroom. But if there's a means problem in terms of having it available to everyone, that's where reform should come in. Because I don't think that people will deny that it's bad to have students spend time with employers. It's just if they can get there.
Other comments from up here, but let's ask the audience if some people would walk to the microphone with some points to make and some questions. After a long day. We'll pay you. Okay. Who won the?
Well, this is just a response to the last point made. I teach here at George Washington University and not in the law school, and I deal with a lot of graduate student internships. And the problem that most of my students have, I mean, many of them do internships and have done them before, but that they work full or part-time during the day and go to school in the evening. And so in order to do an internship, they have to be able to afford to take time off of work. And that's where and it's not like it's time that they'd otherwise just be sitting around school or something. And that's where the inequality comes in. And some people have the means through parental support and other things to do that. They know that it's an investment into the future, but you have to sort of have the cash up front to pay the landlord. You can't say, wait till after I graduate and get a better job. But I think that's sort of in some ways belaboring the obvious. But I was kind of, not to fault anyone here, but kind of disappointed that the policy discussion wasn't a little broader, because I think I agree very much with the kind of things that Catherine was saying in terms of employment law, but I think that there are other policies to think of. I mean, Title IX, for example, as another way of dealing with discrimination and sexual harassment, that that if students are not considered employees, then there are laws that protect them as students. And I think that there are ways, and as was suggested, and maybe the university is responsible, but also employers maybe, if they're have some kind of contract for providing and collaborating with the university in terms of the educational benefit. So I think, I mean, this is not to get away from the issue of the labor law issues, but at the same time, before those are changed, I think there are other things that we could be doing. There's also informal kind of pressure. A lot of us have contracts that organizations sign and interns sign. And I don't know how legally binding they are, but they're a way of sort of suggesting at least that we expect this kind of treatment, and also making it very clear if a student is not treated well, you're not going to get any more students from us, and we're going to widely publicize that. So there, I think, you know, this isn't instead of the law, but I think there are lots of other ways of putting pressure on employers who are using interns to use them more responsibly.
It's a very good suggestion.
Let me make 3 quick points that have occurred to me sitting here, and really build on what you just said. One is, boy, I think, and I certainly hadn't thought of this before today, I think every university had better draft about a 2.5-page thing that says, what is this going to be about, and what are some of these laws, and what are some of these things, and how do we do it, and you shouldn't let anybody go off anywhere during semester, summer, supported by the school, whatever, without some clarity about, because the number of fuzzy, uncertain things, if this were my kid, you know, I'd really see issues and wouldn't know the answers. The second thing is, this discussion is making me think, there's a sort of period now, my kids are older than this and my grandchildren are not old enough to be in it, but a period that you could roughly call the age group where the 2-digit number and the first one's a 2 of your age, you know, that's sort of after high school and before sort of grown-up life, that's become, for an awful lot of people, a pretty long period. I mean, it's not 10 minutes, you know, you go to college or high school, and then you're in the military, and then you do this and whatever, and then you're married at 22 or something. A real period that's sort of open there, and we got to give some social policy thought to what are the other stages of education, and in that period, where's the workers' comp protection if you get hurt on the job or at a job, whether you're a worker or not? What's the health benefits story, which has been somewhat improved by the new Obama law about, you know, being able to be on, if your parents have a plan, which not everybody does, and other things for this period that's kind of the intervening between childhood and adulthood, and I don't even know what the word for it is going to be, but these are real policy issues that I think deserve much more attention, and as several people have said, not just from the Department of Labor. I mean, they come elsewhere as well in the public policy world. Catherine. You
know, if I can add something on the university education, I actually think that this is a place that universities can really shine. So I'm going to use like a quick
university, I couldn't understand.
That they can really shine at. I mean, this is something that they're good at. So I studied abroad my summer after my freshman year, and I was going to, of all places, Ireland. And I had 2 8-hour seminars with the university before I was allowed to leave. Wow. Essentially because I was trying to get credit with the University College Dublin. And before I could get credit from them, I had to take 2 8 hours of seminar, where I covered all manners of things, like proving that I had health insurance for the duration of my trip abroad, understanding what it meant that if I had to repatriate my remains, I had some type of insurance coverage to pay for my dead body to go back home, how to get money from a bank, how I'm charged based on international conversion fees if I go to an ATM twice a day versus 3 times a day versus trying to pay for like a $2 soda with my debit card, right? These are all things we went over in 2 8-hour seminars before I was approved to get credit to go study abroad in Ireland, right? And when I went to Russia, I was like 4 weeks. But it was very clear that they knew what the problem was, they knew what they wanted to tell students, and they grounded into you, this is how you're going to make it, and this is what you need to know before you leave. I think if they did that for internships, and they said, here's what the law says, here's what employment, relations are like, and we'll even give you tips on how to like tie your tie so you're not, so you're an actual employee. I mean, I think that the university can do this, and I think that they can do it very well. And I think if they did, our job as policymakers would be so much easier.
Yeah.
Because if you came from a place where students knew exactly what they were getting into and exactly what this law held, even if we still don't know, that we would be coming from a better place in terms of making the system work for everybody.
Emily, do you guys do a lot of that when the kids go
We do
up?
some, but I'm sitting here thinking about the
Maybe
things we
more,
could add.
yeah,
I'm
yeah.
not sure, I mean, I think it would be way better, but I'm not sure it would solve the problems we're talking about today.
No, it certainly wouldn't solve all
I
of them.
But yeah, it's definitely food for thought.
I see the next question.
So I'm coming at this from, I work at a law school in a career center. A lot of, especially after the New York Times article and other articles being in the news, students actually are familiar to some extent. The law students specifically are familiar with what the law is, and they come in and they ask, well, so what do I do then? If an employer is not willing to pay me, realistically speaking, I still need to get this experience. So as much as we educate them, there's only, I guess, so much we can do. So what are your ideas for solutions? What can we tell students? I mean, is it don't take the internship, let's institute a boycott? Is it, insist on payment? Is it call the Department of Labor? Or is it, what? You're just stuck with that. You have to do it.
Go to the Department of Labor.
Do you find the employers, or do they find the employers?
They do.
Because we find the employers at Northeastern predominantly. And I think that changes the conversation a lot, because we have conversations with the employers directly. When a student comes in and says, I found this employer and they'll take me on for free and I really want to do it, and how do I, make whatever arrangements? I mean, you can suggest to them, if you think it's appropriate, that they should go back and have a different conversation with the employer, but they may put the internship at risk. There's no question about it. And I don't know that, and I think that's very difficult for students. It's
I think the schools have to be very wary here, because I suspect the students that are attracted, students know they'd rather get paid, number one.
Yeah,
And they'd
that's
rather
true.
have a real law firm job than none. And the students that I deal with that are entertaining internships are students that are having trouble getting those jobs. And I think the university's job should be to facilitate that, because ultimately they will have a good placement. They're in a better position taking something like that for the short term than they are, in my view, not getting it because we insist on the minimum wage, which is not their objective anyway. I mean, I just think it's just not our business as a university, it seems to me. And by the way, the law is not clear here. And so if telling them the law is clear is a misconception.
There was an opinion letter from the Department of Labor on the issue of law clerks,
Yes.
unpaid law clerks, finding that they were not employees. I don't have the cite
That's
to
good.
it. It was,
Working for judges?
no, it was a foundation that had a law clerks.
Well, there are
in
two
their
opinion
office.
letters in this book. Is it in
Is
there?
it in here? I don't
No?
know.
All right.
I don't have it with me. I'm sorry.
But
But-
if they've been educationally connected and it's tied to courses, you can't tell them. That's the problem, because all these things are disconnected.
Well, actually, it was interesting to me partly because my impression, with all due respect to the person who was here from DOL, my impression reading the various opinions that have been issued by Wage and Hour is that they tilt toward allowing unpaid internships within degree programs and not otherwise, but that it is an inconsistent result. And so in this particular case, it actually sounded like they were balancing, they weren't using the strict language of number 4 in the fact sheet, but rather were balancing the benefit to the law clerk against the benefit to the employer, and concluding that it tilted in favor of allowing an unpaid situation. So, and I apologize, I should have had it here, but I don't.
I think I see you, please.
Sure. I do have a sort of a follow-up question from the last one. Two parts. One, I think unless the DOL comes down firmer, there's not probably going to be an industry change, and the students are so eager to work that they're going to continue to allow it to happen. So then I get into the question of, for faculty at my university, and I'm sure others here, the faculty make the decision about whether it's academically worthy. So if a student shows up with unpaid internship, the faculty likes the content. Does the faculty need to check that the 6 points are being met in order to give credit? And I know faculty on my campus are not comfortable doing that. So I just wanted to hear if anyone else had thoughts about that.
Are these for-profit employers?
It can be. Very often, yes.
I
but
don't
it
think the
doesn't
6
have to be.
points have anything to do with what your mission as an academic institution. You need to make sure that the internship is serving educational purposes for the student. The 6 points are simply rules of thumb for the staff to decide whether they're going to bring on an investigation. It has to do just with the labor law aspects. It has nothing to do with the educational aspect. So that's your job. Does it tie in some way with courses the student's taking? Is there some sort of coherent design to it? It's your job. It's not the it's not to refer to the 6 points.
Well, I think that there is a responsibility to connect students to internships where they're being treated legally.
I don't know what that means, sir. I really don't. If it's an
Connecting
educational
students to a for-profit employer that's not complying with the 6-part test, you don't think that's the university's
this 6-part
responsibility?
test has no legal status. I hate to tell you this, because the only word in the statute that they're elaborating is the word employ. And if it's a university supervised program that serves an educational purpose, it does not have to be paid, whether it's for profit or not for profit.
You said a second ago that the Labor Department has no business intruding in this matter, but it does. And the definition of employment under the FLSA is the broadest of any statute. It's their business to make sure that people who are doing work that falls under the FLSA should be subject to minimum wage and overtime protections. And
they have no business, in my view, with some of the factors. I agree with some of the factors, but some of the factors make no sense.
Well, there's no exemption under the statute for students.
No. But the question is whether the 6-part test is
It's from a
correctly.
Supreme Court case.
No, it's not direct. Actually, that's a sort of interesting question, which I thought was interesting. Didn't come up in the prior panel, but
Which Supreme
it's
Court?
definitely the 1947 case didn't lay out these 6. You can derive them sort of from the dicta in the case. It is not laid out in this way, and the no immediate advantage language was, in this case, there was no immediate advantage to the employer. Not in all cases there needs to be no immediate advantage to the employer. So this is very much a derivative document. But to go back to the question that was asked, so I'm actually sitting here pondering this. What is our obligation as an institution? It seems to me that Sam is exactly right, that the primary obligation in the situation where you're approving something for credit is, does it meet the educational institution's obligations to the student? To go back to the concern that was raised before, they're paying you a whole lot of money for those credits. If you're at GW or Georgetown or one of the other private institutions or Northeastern. On the other hand, I'm not sure you shouldn't say to the student, there are some wage and hour obligations that employers have, and that runs between the employee and the employer. And the student is entitled to know that whether that this is the status of the law, whether you think it's a gray area or not, and the employer may or may not be willing to go forward with it. But it seems to me that if you have an obligation to the student, it's to say, we believe this is a very educational and useful thing to do. We think you should know that there are these other factors that might influence your decision as to whether to do this.
What if this were a job after graduation that was clearly employment, but it was not paying minimum wage? It was with an employer
Then
that
the
was
faculty
paying.
has nothing to do with it.
Huh?
Nobody's coming to a faculty to ask for approval of that. I actually feel very strongly about the postgraduate situation, that people should be paid. But I don't.
But in a career services office, where you're hooking up, going to find employment after
We
you
don't
graduate.
hook people up for illegal jobs.
Well, exactly. That's my point.
Just a note on the 6-part test, and kind of from our discussion earlier. I mean, it's the Department of Labor's job to protect workers. I mean, it might be a test that we're all, planning to come to terms with, but it's the Department of Labor. It is their purview to protect workers and to put in workplace protection. And this test might be confusing. It's still pretty clear about the fact that there can't be an unpaid internship at for-profits. It'd be very difficult to justify that. I feel very strongly about the fact that the policy moving forward would be to make this test clear, to make this test more enforceable, and to make this test more understandable, so that when we go forward, it can be college, career advising, and that you can have a very clear answer to give to your students. I mean, I think that that's the policy, is not to somehow take something away from the Department of Labor, which is clearly theirs. This is a worker issue, so it is theirs, and I think that making it clear is what we should do, and not somehow say it's entirely up to the university to make sure that internships for their students are okay, because frankly that doesn't cover anything. I mean, it doesn't cover post-graduation internships.
We're essentially running out of time, so let's take the 2 points of the people who are standing up, and then we'll see if anybody says anything about them, and we'll go.
Hi, my name is Stephanie Dector. I work across the street at the law school here in the Career Development Office, and I have a question that kind of takes a little bit out of the realm we've been discussing so far. I work with a lot of international students who are on F1 visas,
right.
And apparently that's exciting. And they have even more restrictions on them.
Right.
They're not allowed to work essentially off campus for money. Yet it is essential for them. My students are only here in a one-year degree program, and so how on earth do they get a job to even do for their optional practical training, which they can do after they graduate, if they've secured a position, if they can't even get a foot in the door to do some sort of work in the country that they're hoping to work? So what do you recommend for that?
Yes. Now let's take the next point also. That one's unanswerable.
I agree with you. I've been
Please.
there. I work for the Duke University Career Center, and I completely agree with what's being said with regards to credit and not credit, and how if an internship has academic rigor attached to it, that could be a good thing. At the same time, where we stand as a career center is exactly what Kelly was trying to illustrate as a point, and I think Emily was going there as well. We are in a very, very difficult situation with this particular fact sheet and these particular regulations, because as a career center, it is our obligation to protect the students. At the same time, it is not our obligation or our job to interpret whether or not someone is doing something legally or not. So without clarity on these particular issues, we have no leg to stand on. For example, our friend who was here from Sirius earlier, I have no doubt that their internship program is a phenomenal program that offers immense benefits to the students who are participatory in that opportunity. At the same time, as this is written, it may seem that that particular internship may or may not be within the realms of the law. But where does my center stand? Should we post that internship or should we not? How do we educate the students with giving fair ability to the employer to not say to the students, this employer is breaking the law? Because we are not lawyers and we do not interpret law. So we are in a very, very interesting situation as career centers, especially when we don't issue academic credit to validate the academic components of the programs.
That's a really good final point for the day, in a way. I want to say 2 concluding things. One is, it's absolutely clear that there is so much uncertainty here that efforts in different relevant organizations and government and whatever it is to achieve greater clarity and have more defensible policy is desirable, and I hope that this meeting will in some way have played a role in contributing to that. The second thing is, I think everybody in the room should thank Alan Morrison and the other George Washington people for what's been a really valuable day. Alan has more he's going to say. The meeting isn't quite over, but this is my chance to ask all of us to give some applause to all the people who have done.
Thank you. I'll be very quick. The question is, where do we go from here? Why don't you just stay seated? I will be quick, and it'll be quicker if you stay seated. The question is where we go from here. In one sense, we could congratulate ourselves of having brought all these issues out of the table and had a nice intellectual discussion. But I think that most of us feel that we ought to think about whether there's something else that people in this room and others who are interested in this issue can and should do. I don't know what it is. Maybe Sam is right that we should get a bunch of people together and go over to the Department of Labor and help them draft some regulations. Maybe we should think about the roles of universities. Maybe we should think about getting some people in Congress interested in it. Congress has been decidedly uninterested. We tried to get some people to come from the staffs. They were unavailable. I'm not quite sure entirely why. So let me propose two things. One is that we have a website up, and if anybody has anything they didn't get a chance to say or want to respond to anything else said, pick up one of these cards on the way out. It's got the website. That's where everything's going to be posted. Feel free to communicate with that. Second, people who are interested in doing something or have some ideas about what they've done, feel free to communicate directly with me. The easiest thing to do is, rather than trying to remember my email, is to go to the GW Law School website, Alan B. Morrison. You can find me there. Send me an email, and we'll think about what we can do from here. My sense is that we ought to do something. We ought not to sit back and put our heads in the sand and hope that things get better. I think there's too much uncertainty, and I think we have responsibilities to students and to our universities and to employers and to everybody else to do something about it. I just don't know what it is quite yet. Thank you all for coming, and I appreciate it. And thank all the panelists and everybody who helped out today.